Hello and welcome back to our video updates. It's Sade here. Today's video is going to discuss assignments, and typically an assignment means that you assigned your rights and obligations to a different party, and those will be the rights and obligations under a specific contract. In this particular video, I'm going to use the mortgages as an example because a lot of homeowners, when they close on the purchase of real estate, they are surprised that the lenders have transferred their loan to a different lender so quickly. Sometimes they transfer the loan the same month in which you do the closing, and sometimes they will transfer that loan maybe a year or two later. But a lot of loans, you'll notice they exchange hands or transfer out several times during the life of that loan. So what exactly are the rights and obligations of the parties? What does an assignment truly say you can or cannot do? All of those rights and obligations will be specified within each contract. So the contract provisions would govern whether or not the borrower can or cannot assign the rights and obligations that the borrower has under the agreement. And then the terms and provisions will also say whether the lender can or cannot. But usually, since the lender is the one that's calling the shots, the lenders can all the time assign their rights and obligations. And they would do that using some clearinghouses that are already there. The most common one that everybody knows about is MERS. So the lenders would have the right to assign that debt to a different party. Or in other words, they have the right to assign the right to collect on the debt and all the rights that come with the promissory note and the deed of trust. They're allowed to transfer that to a different party, and sometimes they do it right away, and sometimes they do it after a few years. And sometimes your mortgage stays with the same lender throughout the life of the loan, but that is very, very rare. So that's essentially what an assignment is party A gives to party B the right to collect on that debt when it's to do with a debt. And the rights are already stated inside the deed of trust, so that allows the lender to do that. A lot of people complain that their loan has exchanged hands a few times, and it can be detrimental because the accounting could get screwed up when they're transferring this debt, back and forth. When they're transferring this debt from one party to the next, the accounting might be screwed up in some situations because the lenders, they use servicing companies, and the servicing companies, also called servicers, are essentially like a manager of the accounts. So they manage the collection of the mortgage payments, and they record those mortgage payments, and they are supposed to keep good files, good records of all that was paid and collected. But sometimes when there is an assignment of that particular note, and the deed of trust usually would go with the note, the new servicer may not have received the last couple of payments collected by the previous servicer. They might not have recorded that inside the account history. So sometimes you run into issues with the accounting based on that. The new servicer might not have recorded the last couple of payments that you made to the old servicer while the account was being transferred over. The other type of assignment you can have, of course, is the assignment of the borrower's rights. And the deed of trust is that instrument that governs the way that you would conduct yourselves as borrower and lender inside the agreement. So that deed of trust is the second document which says that you do own that real estate, but it's a collateral for the lender. So you're restricted in the things that you can do. And typically the borrower is not allowed to assign the borrower's rights to another party without first getting consent from the lender. And the rights and obligations that the borrower has, they're more in the sense of obligation. So those are the main issues that people would run into, is that the new servicer does not have accurate records, and they're saying that you're behind on your payments when you're not. So then all you have to do is to request a detailed account history from that new servicer, and they're required to show you all the history from the inception, from the initiation of the loan itself. So when you're looking at the note is that part that says that the borrower has to pay back whatever was borrowed to be able to purchase the property. And the deed of trust is actually the security instrument that secures the collateral. So those are two different things, but they transfer them together typically. If they don't transfer them together, then the lender would run into issues, the new lender that took the assignment. So the assignment is supposed to assign the note and the deed of trust. Now, the deed of trust binds both the borrowers and the lenders. However, since the borrower is more at the mercy of the lender, they restrict the borrower's rights to assign that contract to a different party. So the borrower can assign, but only with the consent of the lender. And that just means no most times, because the lenders don't trust that the new party would make all the payments that you promised to make under that contract. However, if they do allow such assignment, they would probably have to qualify the new party that's taking over the loan. So the borrower has more of obligations than rights. There are some rights, but there are lots more obligations under the note and the deed of trust. Most people will still go ahead and do the assignment as borrowers without the consent of the lender. The lender has a due on sale clause, typically inside the deed of trust, that says that if you do transfer your rights and obligations to another party without consent of the lender, you risk the lender being able to call all of that note due all at once. So let's say that you were paying for a couple of years and your note still has about 28 years left. The note is supposed to be paid off in the future, but in year 2, you decided you needed to get out of that deal and you wanted to transfer your rights to a new party. The person does not have great credit, and so they wouldn't qualify on their own. So you try to do a transaction where you assign to them under an assumption agreement, but you don't notify the lender. So that means the lender has the right to ask for all of the total loan amounts due, even though it's not yet 28 years later. So that's what due upon sale clause means. Most lenders tend to look the other way. Of course, people can also assign their right to make a claim to something, or their right to sue, in court. So you can do different types of assignments. There has to be consideration for the assignment. So consideration means usually a payment that the person makes in order for you to be able to prove that there was an offer and an acceptance and there was a real deal, not just a sham deal. So if it's your family member, they still should pay a little bit of money unless you're giving it to them. So hopefully this video has been helpful to you. Remember, assignments can be done by either side of the deals, typically, unless your contract says not. And most times when it says not, it just means that you have to get written consent from the other party to be able to do it. Thanks for watching as always, and I'll talk to you next time.